My lord, access to justice is a fundamental right. We say that, we know that. There are 2 million pending cases, and I'm sorry to start with this, but there are 2 million pending cases at this point in time. And you have the unique experience of practicing law for about 2 decades, and now you've been on the bench for almost nearly 3 years. How do you address this question? Is there really access to law at all?
I think that's the million-dollar question that we struggle with on an everyday basis. It's a big country, right, and fairly litigious. Until I came into this role, I didn't really realize the pressure of time on judges. So on an average day, there are 40 to 50 cases fixed in my court. So you start out the day hearing the arguments. You've got to write, like every case that's fixed, something will be written, even if it's simply that the lawyer is absent and the case has to be adjourned. You do a 3-hour session, 2.5-hour session, then there's a 30-minute break, then you go into a divisional bench, there'll be another 30, 40 cases fixed there. You will come back to your chamber by like 2:30. You've got to then dictate the shorter orders for the day, correct them. By the time you're done with that kind of work, it's almost 4:35. You've not had the time to really think about case law, any deeper thought into anything that you've heard during the day. And you'll get the list of the 70 or 80 cases fixed before you for the next day, and the files will come in. And then, that evening you have to read those files to be prepared for those cases. So there's an absolute rush of time. The more you think about it, the more you realize that unless this inflow versus outflow is fixed in a rational manner, you can appoint any number of judges and there'll still be pendency. So there are 2 or 3 different ways of thinking about it. A, not everything should come into the stream of litigation. So there has to be effective ADR mechanisms. There is an ADR law that's in effect. I think in most of the provinces and Islamabad, they have their own provincial laws. We have one under which rules have been framed, and we've also issued a practice guideline. We now have, I think, 50 trained mediators, and we're trying very hard to get judges acclimatized to the idea of encouraging people to go into mediation, to have things resolved outside of the court system. So that's one aspect of it, to prevent the inflow. The second then would be limine control, where there is no need to admit all cases on the first day, because once a frivolous case, even a frivolous case comes into the system, then service has to be effected, lawyers have to be appointed, they'll file their responses, you've got to hear the whole thing and then decide it. So judges have to be fairly adept and ruthless in terms of looking at the merits of a case on day one and saying it cannot get into the system because this is a decided question of law, or we cannot hear this for X, Y, and Z reason. And those tests are there. That's one. Then there have to be costs. Anyone who comes into the litigation stream, it cannot possibly be a free ride, because once you issue notice, the other party will appoint counsel. Everyone is bearing costs. The public is, because legitimate cases will not be heard and there'll be delays. And somebody will have hired a lawyer, paid them money, and it'll continue on for. So that is another way of managing that. Not everything comes into the stream, and to the extent that frivolous cases come into the stream, then there is some deterrence. On top of it, then there has to be judicial training. Obviously, we don't have effective training as an institution. One has to admit that. I, as a High Court judge, have not been trained. As a lawyer, you are in a different role. You are appointed a judge. I think this might just be the only institution that will not train you at all, and just put you on the bench day one, and you start to hear cases. And it's only through experience that you figure out things. There is absolutely no harm that judges, even High Court judges, should be effectively trained. As a routine matter and in specialized areas, there have to be specialized benches. We don't usually have that right now. So I can be hearing a bail matter, and then an appeal in a civil matter, and then a company matter, and then a tax matter. all on the same day. So you're kind of all over the place. So that kind of case management system isn't there. So there is a lot that is wrong. We're a public sector institution. We're still working in the 20th century. We don't have digital records. We're working with paper. Things are extremely slow. Even our staff isn't trained. So, like, we know what the problems are, but to change how things are done in a public sector organization is exceptionally hard, is what my experience has been over the last 3 years. Encouraging people, whether it's the lawyers, whether it's the judges, whether it's the court staff, it's exceedingly difficult to get them to change how things are being done. We have put together a reform project. We are in the process of figuring out how to digitize with a vision that in another 5-6 years, it should be a completely digital court. Once our data is digitized, somebody will be able to analyze what streams get stuck where. We don't have the benefit of that right now. So fairly commonsensical things. Unfortunately, we haven't done them yet.
How do you segregate those people who probably did not have access to or the pockets to hire a lawyer who was capable or competent enough, because that issue exists, it's a very live issue, to represent his or her claim, and does not have the resources to pay the cost of a party who has hired, let's say, a lawyer who has charged them an arm and a leg? So how do you balance that? And secondly, what are the low-hanging fruits? I mean, we talk about reforms. There was an Asian Development Bank Access to Justice program, $350 million, although we never saw the whole thing. But what are the low-hanging fruits that do not require a lot of financial resources that you believe we can achieve, and which will actually help the system in general? So these two questions I'll put to you, please.
I think the judiciary has to start from a place of humility, in a sense that we've got a limited role. In a society where, and in any society, there isn't economic equality. Consequently, there isn't social equality. And there will be no legal equality. To pretend otherwise, would be to imagining things. It cannot be for judges to ensure equal access to the judicial organ. Because if somebody doesn't have the money to hire a lawyer, then they're cut out, obviously. In criminal matters, you will appoint a state counsel, because obviously somebody's right to liberty is being affected, but a state counsel who's doing something for a pittance or for free will not put in the kind of effort that a lawyer who's an expert in his domain and is charging high fees will put it. So there is no legal equality in that context. The judges cannot do much. I think this is for the parliament, and there are legal assistance programs. There is some money that goes into it. How it is actually being utilized. For example, Islamabad doesn't have a prosecution service. The capital has been there for whatever, since 1960 at least, but we don't have a prosecution service. So there are issues of that sort. And there are other issues with the system. When you look at the criminal justice system, for example, the amount allocated for each investigation is so small that nothing decent can come out of it. And so investigations are badly conducted. Once an investigation is badly conducted, the prosecution cannot do too much, and the judge can absolutely not do much because he's got to decide on the basis of the file that comes before him. We've got a very high acquittal rate for that reason. And fine, in public perception, it is the judges which will end up taking the blame because they've acquitted somebody. But as a judge, you're sitting there and you're saying the evidence doesn't prove beyond reasonable doubt that the person should be put behind bars, and so what is it that you can do? But the system is slow. Somebody will be let go, not because they're innocent, but because their guilt has not been established beyond reasonable doubt, maybe at the High Court level or the Supreme Court level. The person would have been behind bars for 10 years, for example, and people will say, now look at these judges, who should be punished for letting somebody go after 10 or 15 years who was innocent? Now, there's a difference between innocence and between not being guilty, but there is very little that the courts can do about it. This falls within the domain of the executive, within the domain of the legislature. So, in terms of what the courts can, I think as a judge, I can say I'm cognizant of the fact that, well, my professor at Harvard, Richard Fallon, wrote about legitimacy and the Constitution, and he said judges have, the judiciary can or cannot have moral legitimacy, which means people accept that we need a judiciary as a moral element. That's where the whole conversation about military courts comes in. If there can be military courts or executive courts, then why do you need the judges as a separate institution? Then there is sociological legitimacy, which is something Zahid Saab was just talking about. Do people perceive that judges are independent and working efficiently? And unfortunately, in that area, we suffer. And then there is legal legitimacy, as in the legal reasoning that we give for any particular decision. And I think there we are mostly okay. You know, when you actually analyze, ultimately mistakes may be made at the civil court, it will be fixed at the high court. If the high court makes a mistake, that gets fixed at the Supreme Court level. So ultimately, generally, justice will be done, but there is the question of delay. So in this larger context, you want your courts to be predictable, so that if you as a lawyer are to advise as to whether the case should go to court, you can say, well, this is going to be decided against you because there's very clear case law. I think we need to lay out very clear tests. Sometimes we do that, sometimes our jurisprudence is quite muddled. I think that needs to be fixed, which will create more predictability. There needs to be a clear sense in people that we are impartial. Unfortunately, and mostly because of political cases, we get a bad rep there as well, because people suspect our motives for why we decide things in one way or the other. So on impartiality, we suffer. And then there is efficiency, and that's again a place where we're suffering, because whether it's for lack of judges, whether it's for too much case law, whether it's for the free ride that there are no costs awarded, things take too much time. Are there fixes? There are fixes. I think there is low-hanging fruit. We shouldn't have a problem putting in place a case management system. We shouldn't have a problem putting in place a court management system where both the judges, the court staff, because there's a huge bureaucracy within the court system, what we call the registrar's office, that kind of will fix cases, will move the files along, etc., etc. They're not trained in a traditional sense. They're trained on the job. That has to be fixed. It can be fixed fairly easily. We don't have a human resource system, for the most part. It's not like you're analyzing whether, like the establishment division within the civil bureaucracy or the MS branch within the army, we don't have an effective HR function where we're looking at individual judges and saying, okay, fine, he needs to get trained in this, and then given this experience, and then he'll move on to do X, Y, and Z. So we're just too focused on our day-to-day cases, and we're trying to decide them, and that function is kind of getting left out. Can it be fixed? I think it can be fixed fairly easily, so long as everyone is aligned that we don't want to create particular outcomes in cases. Because if you create this very transparent system, then it becomes very, very hard to control. And if it is very hard to control, then you cannot produce desirable outcomes in X or Y case either. And I think that to me seems to be the biggest stumbling block.
Just one question for Justice Saab. So you have, जब हम हाई कोर्ट में जाते हैं, tenure post है. I mean, no one can remove you, and obviously there's certainty, and I know if I have a case fixed before you, there's unlikely that the case is going to be, unless and until you recuse yourself, the case is going to stay with you and you will decide it. Can we not replicate the same system in the lower judiciary, where why is it कि एक judge 3 महीने में transfer हो जाता है, civil judge, and वो एक case की life अगर 3 साल हो तो वो 4-5 दफ़ा तो on average एक transfer posting चलती रहती है from west to east and east to west. Can we not, isn't this a low-hanging fruit where we can somehow ensure or pass a directive that you have to serve for 1 year or 1.5 years in one court?
ہو سکتا ہے. دیکھیے, I said before, we don't have an effective HR management system. Now, a judge might be mature for a promotion or a training, and so he's going to be transferred to do X, Y, and Z. That's one circumstance جس میں یہ ہو جاتا ہے. اب کیسز پھر بھی چلتے رہیں گے. آپ کو یہ بھی دیکھنا ہے کہ لوگوں کو, اچھا, then sometimes we'll get reports at the high court level. There is going to be an inspection judge. He'll come out and say the performance of this person, because they're wearing multiple hats, he might be a magistrate as well as a civil judge, in criminal cases isn't too great. He doesn't have a great understanding of it. تو آپ اس سے وہ ڈاکٹ واپس لے لیں گے, کسی اور کو دیں گے. بٹ obviously the person جس کا کیس آپ نے لیا وہ کہے گا آدھا کیس اس نے بھی سنا تھا, اسٹارٹ ہوا تھا, اب کیس ٹرانسفر ہو گیا, جس طرح زاہد صاحب بھی کہہ رہے تھے. So there are those issues of efficiency. اسلام آباد میں پھر بھی کم ہے, because we don't, it's not they're just two districts, so وہیں پہ زیادہ رہتے ہیں. But there is absolutely no reason why there cannot be fixed 2 to 3 year tenures جس کے اندر آپ نے ایک خاص طریقے سے چلنا ہے. But a lot of times our cases are not court driven, although even if you read CPC sensibly, it has to be court driven. کہ آپ لائرس کے ساتھ ایک پری ٹرائل کانفرنس کریں, آپ بتائیں اچھا یہ اسکیجول ہے, اس طرح سے ہم اس ٹرائل کو کریں گے. بٹ ہم نے اپنا جو کسٹمری ہماری پریکٹس ہے بٹوین دا بار اینڈ دا بینچ, وہ اس طرح کی بن گئی ہے کہ آپ ایک دن لگے گا کیس, پھر 2 مہینے بعد لگ جائے گا, پھر 2 مہینے. اٹس این ایکسٹریملی inefficient way of doing it. We're trying to fix it. Let's see if that succeeds.